Wait, you need to stop talking. Is Mr. Griffin, are you Mr. Griffin or not?
I am Anthony of the Griffin family.
Are you the Anthony Griffin that is charged? Stop a second here. If you keep talking over me, we're gonna cancel this.
Talking over me. Matter of fact, Your Honor,
Before we even get into this courtroom chaos, let me warn you right now, this is not your average hearing. What you're about to witness is a full-blown collision between reality and the sovereign citizen fantasy world. We've got a defendant who refuses to acknowledge his own name, denies basic identity, and believes saying certain words magically dissolves criminal charges. On the other side, we've got a judge who is clearly not here to entertain conspiracy theories, word games, or courtroom cosplay. This case unfolds fast, and it gets wild almost immediately. Talking over the judge, rejecting jurisdiction, claiming to be a living man, and invoking imaginary legal doctrines. It's all hay. The tension escalates quickly, patience wears thin, and the consequences become very real. So as you watch this play out, ask yourself, is this confidence or self-destruction in real time? Buckle up, because this one spirals hard, and the courtroom does not blink.
The State of Wisconsin versus Anthony Griffin Jr., case number 25CF939. Could you get the appearances, please?
Assistant District Attorney Jack Schneider for the State of Wisconsin.
And you're Mr. Griffin, is that correct?
No, all statements for the record comes now the living man, Anthony of the Griffin family.
All right, so Mr. Griffin,
appearing expressly.
wait, you need to stop talking. Is Mr. Griffin
appearing expressly
hearing today? Are you Mr. Griffin or not?
I am Anthony of the Griffin family.
Are you the Anthony Griffin that is charged? Stop a second here.
You asked me a question, I'm answering it.
Okay, I don't want you to answer it anymore. I want a yes or no answer to a question, okay? And the question is, and I have to get the case back in front of me, I'm sorry, but bear with me. Lost my calendar. I have a simple question for you.
25CF939.
Are you Anthony Griffin with a date of birth of August 20th, 1985?
I am not the dead entity Anthony Griffin. I am the executor of the estate. I do not agree to be.
All right, well, we'll have to set this over and hold you in custody then until we can have a later hearing.
As I've been held for 72 hours without seeing the judge. That is unlawful.
But you're not Anthony Griffin.
So you are agreeing to violate my common law rights. Is that what you're saying?
I'm asking you to, let's do this. Okay. I'm going to find probable cause that this is Mr. Griffin that is acting in an obstructing way, but we'll go ahead with it. Do you have a copy of the complaint there in front of you?
I object that you're obstructing my justice.
Your objection is noted.
I'm a more.
If you keep talking over me, we're going to cancel this.
Talking over me. I just want to state the facts. Do you not want the facts to be stated on the case? Am I not allowed?
You're not allowed. No, you're not allowed to talk about
an attorney. I am not.
Okay, let's hold him in custody or canceling this hearing. You're going to have to be held. You're not willing to cooperate. Make a record
show that they're violating my rights. Let the record show that, please. Thank you.
Right here is where everything starts going downhill, fast. The judge is asking a simple, procedural question. Are you the person charged in this case? That's it. No trick. No trap. But instead of answering yes or no, Griffin launches into sovereign citizen script mode. This is a textbook tactic. Separate the living man from the legal name, claim to be an executor of an estate, and hope the court somehow collapses under semantic pressure. But here's the reality check. Courts do not operate on metaphors, vibes, or philosophical identity debates. Identity is established through custody, records, and presence, not wordplay. When defendants refuse to acknowledge basic facts like their name or date of birth, judges interpret that as obstruction, not intelligence. And once the court sees obstruction, patience disappears fast. This isn't strategy. It's self-sabotage.
We'll go on the record in the State of Wisconsin versus Anthony Griffin Jr. That's 25CF939 appearances.
Mr. Reed Marco for the state.
Understand order with the defendant's office defers to Mr. Griffin, who's indicated that he wants to take care of his own case.
Right. Is that right, Mr. Griffin?
No, I'm not Mr. Griffin. Anthony of the Griffin. I have the power of attorney for him. I do have a question for the court. Will I be allowed to speak freely, or will my civil rights be again
Oh, you get to make a statement on bail, but we're going to do this in an orderly fashion, but you're indicating that you're not Mr. Griffin, or that's just not how you identify yourself?
It's not about me identifying myself and be Griffin. There's my all caps entity with the dead entity. I actually have an EIN for this created entity. This is not me. I also do not live this address. I'm also not a black man. I am a Lord. So a lot of things on here totally wrong, which not be at all. My weight is not 240 pounds. All this information is false. But as for the record, all statements for the record comes now the living man and the other Griffin family. Sure, yours or your son status appearing expressly to continue the regular support. I'm not to be mistaken with the all caps state, as I am the occupant of the executive office and also the sole beneficiary of the state. I found my power.
This moment is critical, and a lot of people miss why. The judge isn't punishing him for his beliefs. He's responding to non-cooperation. Courts are required to confirm identity before proceeding. When someone refuses to do that, the court literally cannot move forward. So what happens? Custody continues. Sovereign citizens love to scream about unlawful detention, but they conveniently ignore the part where they caused the delay. If you refuse to confirm who you are, the court has no obligation to play guessing games. And notice how quickly the tone changes. The judge moves from questions to findings. Probable cause. Obstruction. Hearing cancelled. That escalated because Griffin forced it to. This is the price of turning a courtroom into a podcast rant.
Let the record show that I do not agree to be a surety for the dead entity as it was created from the state and was given to me and is not a representation of me. I am not one who owes debt to the United States or to the state of Wisconsin. Further, I'm not a flight risk. The only reason I was supported was due to the failure of the court to notify me of said date. Furthermore, upon being detained, I made it very clear to Officer Gilson that I wanted my rights read to me. Officer Gilson first refused after we asked him twice more than he read me my rights. After Officer Gilson read me my rights, I made it very clear to him that I wanted my attorney present with the sheriff. Officer Gilson then replied, "They won't come." I made it very clear to him that if he continued to talk to me without my attorney present and the sheriff present, it would be a violation of my civil rights and my constitutional rights. He ignored these facts and continued to be arrested in violation of my law and the rights and the protocol that he agreed to follow as an officer. I was pulled over while I was traveling in a private automobile. The plates read, DOT exempt, do not detain private traveler. I made it very clear to him that he does not have jurisdiction, but yet he forced it. I was never properly identified as a suspect. My fingerprints were taken under direct arrest of origin after I told them I did not want my fingerprints or people taken until I have a court order from the judge. I do not argue with any of the facts in this charging incident. This is not me taking a plea. It's accepted for value and returned for value. All the charges contained in this case and use my exemption for discharge and set off and release the order to me immediately.
Okay. Well, I think there's at least a reasonable inference on the record that the person known as Anthony Griffin is the same individual in front of me. When they called Anthony Griffin's case, he came out of the holding cell.
Let's pause here and give credit where it's due. This judge handled this exactly how it should be handled. No debating conspiracies. No indulging fantasy law. No letting the courtroom turn into open MIC night. He set boundaries, enforced procedure, and moved on. That's important because sovereign citizen tactics rely on dragging judges into endless circular arguments. Once that happens, they claim victory through confusion. But when a judge refuses to engage and instead documents refusal to cooperate, the entire strategy collapses. The record becomes the enemy of the sovereign argument. Calm authority beats loud nonsense every time.
Looking at the court records, please don't interrupt. I'm looking at the jail records.
The Trust Act of 1666 says that when somebody claims their estate, you are to relinquish all of the things to them.
I don't know what you're talking about.
That's
I've never
okay.
heard that ever.
That also means that this
You
is not
can file your written motions, Mr. Griffin.
court with jurisdiction, and I challenge jurisdiction under Federal Rule of Procedure 5.1.
It's denied. The booking photo and the Spillman records match this particular individual.
Right to approve your
I'll find probable cause.
Man can be lowered over his own case.
And where would you like us to send mail, sir?
You already have mail.
Okay,
53532.
Thank you.
And I have a right to
And
be released
what's-
on my own cognizance.
What's
I
the
do not
state's
think this is-
position on bail?
Thank you, Your Honor. In this case, the state is asking the court to impose $1,000 pound bail with the condition that the defendant be prohibited from possessing any dangerous weapons as defined by the statutes. It's my understanding that the defendant posted $5,000 cash on his current pending felony case and then failed to appear in court. He is alleged to have refused to identify himself and has committed additional crimes while out on cash bail, which is, as we know, a general violation of conditions.
I object.
It's our position that
Well,
cash bail-
Let her finish. We can't have this hearing. We are talking over people. We're trying to record it. What's the basis for the
the
objection?
basis for the objection is the fact that she has no basis of knowing who I am. I don't know who she is.
All right.
She's not even.
The objection's overruled.
Overruled an objection.
I ruled it, Mr. Griffin. Let her finish.
As far as that failure to appear, Your Honor, it looks like a bench warrant for a body only hold was issued on January 27th of this year in pending case 24 CF 907. That warrant was not served until almost 3 months later on the 17th of April this year.
So Your Honor, they're sure not that when somebody has a court date that they have to be served a court date so they know that it's there? Or is it okay to actually set a court date without notifying the defendant or the accused and then locking them up for warrant?
All right, and I gather you're alleging that Judge Highland did not send notice to you.
No, there's no certified anything there. There's no document or proof of service of anything of that date. I went to every previous court date and I don't skip court date. He didn't show up for the last 3 court dates prior to that. And I actually put in a motion for failure to prosecute, yet they still moved forward as if nothing was placed in and no one came to court except for me and the prosecutor, and the judge was hiding in the back or whatever the case may be. I filed an abatement, just to let them know I'm not the person who they're looking for, but yet I keep getting trampled over in court. My rights keep trampled over in court. You have this person standing to the left of me who knows me not at all, and yet I would like her to take the stand and talk about how she knows me personally, because you cannot be a beneficiary.
And somehow, it gets worse. This second appearance is a greatest hits album of sovereign citizen talking points. Dead entities, capital letters, jurisdiction challenges, religious status, race denial, private travel plates. It's all here, rapid fire, barely coherent, and legally meaningless. What's dangerous about this isn't just the nonsense, it's the confidence. People watching this might think he sounds informed because he's speaking fast and using legal-sounding words. But none of it applies. None of it overrides statutes. None of it negates jurisdiction. Courts don't recognize magical exemptions just because someone declares them. This is ideology colliding with reality, and reality always wins.
The only warrant, you can't get released on that until you have a hearing with Judge Highland in that case. I think given the history,
So it's clear that
$1,000 cash bail is necessary. I will set that.
I object, and it's clear that
that's
procedures have been violated, and you're still moving forward. This is called an obstruction of justice.
Don't
Let the
think
record
your
show
rights
that.
have been violated.
Everything that I've said.
It's all being recorded, Mr. Griffin. You would have the right to a preliminary hearing in 10 days. Do you want that scheduled?
Well, I don't want to sit in jail any longer.
Okay, well, you're gonna have to get a hearing in front of Judge Highland on the other case. Right now, you're not allowed to post any cash bail to get released in that particular case. I don't have any authority to do anything with that.
So if you don't have authority, that means
You're
you don't
gonna
have
have
authority over me.
to address
I object
that
if you don't
case
have
with him.
authority to actually set me a bail, you do not have authority over me. Matter of fact, Your Honor, are you responsible for me if something happens to me?
All right, and I'll also order that you not use or possess dangerous weapons as it's defined by the state
You're
statute.
responsible for.
And because I haven't heard a response, I don't believe we have a waiver of time limits to set a time for
Are you
preliminary
responsible
hearing.
for me if something happens?
And we are adjourned.
Okay, since you're not responsible for me if something happens to me, let the record show that you are not. He's all right.
This exchange perfectly demonstrates why sovereign citizen arguments fail every single time. The judge is using evidence, booking photos, records, custody logs. Griffin is using imagination. Courts operate on proof, not proclamations. You don't opt out of the legal system by saying the right words. You don't negate charges by rejecting labels. And notice the pattern. Interrupt, object without basis, cite fake laws, then claim persecution when it doesn't work. It's a loop. A very expensive loop. Because while he's arguing theories, the court is making rulings that affect his freedom. This isn't rebellion. It's legal quicksand.